many health and safety implications of precarious work. I'll just take the example of workers who work for temporary employment agencies as an illustration, because each category has different implications. So a triangular employment relationship implies that there's at least three parties. There's the temp agency worker, the temp agency employer, and the client employer, who is the client of the temp agency. The temp agency is the employer for some purposes, the client employer is the employer for other purposes. And what our research has shown is that the employers themselves don't know who's responsible for what, so that in terms of prevention, the temp agency workers don't get the proper protective equipment because each employer thinks it's the other one who's going to provide it. The worker is always a new worker in the sense that they change workplaces all the time, and that increases the probability of accidents or injuries. And finally, in terms of tracing exposures, the workers don't know what they're exposed to because they're new to the work site, and often contaminants they'll breathe in, they'll have skin diseases, and they won't be able to relate it to the work that they're doing. In terms of workers' compensation, what that means is that the worker doesn't know who his employer or her employer is. They're not necessarily provided with adequate information as to where they should file if they want to report an injury or an accident. There is some good evidence that there's a lot of incentives to not report accidents, but the confusion can also, in many cases, facilitate camouflaging accidents. It's much easier to intimidate a worker when the visibility of the employment relationship is shrouded. A more important aspect, and which will vary from one province to the next, is the question of the levels of compensation as such. Quebec is the only province in Canada that guarantees that regardless of what your actual salary is, you can never be compensated for less than 40 hours a week at minimum wage. And that in workers' compensation is extremely important, because what that means is that the salary base will be at least full-time at minimum wage, and that will be driving both your benefits in terms of disability. If you become paraplegic because of that accident, your benefits will be based on a salary at least of minimum wage full-time. That's not true in any other province in Canada. In Ontario, for instance, they're not going to try to readapt you to earn even minimum wage full-time. Not by law. They might do it out of the kindness of their hearts, but they won't legally be obliged to bring you up to anything higher than pre-injury earnings. And if that's $90 a week, then it dooms the worker to poor benefits, poor rehab, poor retraining, and eventually to a life in poverty. The right to return to work exists in all provinces, not necessarily with a guarantee of having your job guaranteed. It does exist in Quebec, but in Ontario, for instance, small workplaces do not have the obligation to bring workers back. But in any case, the employer is the temp agency, and policy, for example, in Ontario states that the temp agency is required to put the worker back on the roster. It doesn't mean that the worker has the right to be placed somewhere. They have the right to be placed on a list. And if the clients don't want somebody with a disability, then that is the product that the temp agency is selling. They guarantee they won't send you somebody with a disability if you don't want them.